Get ready for the dictation in 3, 2, 1, start. This court finds that the apex court considered the power of judicial review as basic structure of the Constitution of India and further the jurisdiction conferred on the High Court by Article 226 of the Constitution of India vis a vis the bar created by the Article 329 was the subject matter of examination before the apex court in the case of Election Commission of India versus Ashok Kumar reported in 2008 SCC 216. Stop. The relevant extract of the judgment is reproduced hereunder that the power of judicial review is a basic structure of constitution is a concept which is no longer in issue. Stop para. Is there any conflict between the jurisdiction conferred on the high courts by Article 226 of the Constitution and the embargoes created by Article 329, and if so, how would they coexist? Came up for the consideration of the Constitution bench of this court in N.P. Swamy versus the returning officer. Stop. The law enunciated in Swamy was extensively dealt with, also amplified by another constitution bench in Mohinder Singh Gill versus Chief Election Commissioner. Stop. The plenary power of Article 329 has been stated by the Constitution bench to be founded on two principles: the preemptory urgency of prompt engineering of the whole election process without intermediate interruptions by way of legal proceedings challenging the step and stages in between the commencement and the conclusion, the provision of a special jurisdiction which can be invoked by an aggrieved party at the end of the election excludes other from the right and remedy being creatures of status and controlled by the Constitution. Stop. On these principles, the conclusions arrived at in Swamy case were so stated in Mohinder Singh Gill's case. Having regard to the important functions which the legislatures have to perform in democratic countries, it has always been recognized to be a matter of first importance that elections should be concluded as early as possible, according to time scheduled, and all controversial matters and all disputes arising out of elections should be postponed till after the elections are over, so that the election proceedings may not be unduly retarded or protracted. Stop para. In conformity with the principle, the scheme of the election law in this country as well as in England is that no significance should be attached to anything which does not affect the election, and if any irregularities are committed while it is in progress and they belong to the category or class which under the law by which elections are governed would have the effect of vitiating the election and enable the person affected to call it in question. They should be brought up before a special tribunal by means of an election petition and not be made the subject of a dispute before any court while the election is in progress. Stop para. However, the Constitution Bench in Mohinder Singh Gill case could not resist commenting on Swami case by observing bracket wide para 25 bracket close that the non-obstance clause in Article 329 pushes out Article 226 where the dispute takes the form of calling in question an election except in special situation pointed out at but left unexplored in Swami case. Stop para. Wide para 29 in Mohinder Singh Gill's case, the Constitution Bench noticed two types of decisions and two types of challenges. The first relating to proceedings which interfere with the progress of the election, and the second which accelerated the completion of the election and acts in furtherance of an election. Stop. A reading of Mohinder Singh Gill's case pointed out that there may be a few controversies which may not attract the wrath of Article 329b. Stop. Thank you.